Yeah. Yeah. Yeah, I mean, I could look at most of the juice section about it. I had some. Yeah. Right. Yeah. It's free. So I live on one. Yeah, I probably works in wide open. Oh, it's like a lot, third block there, yeah. Which I think, so that's right. Yeah, sure. Yeah. We feel all the properties. So it's like that. Yeah. Who access to the tree? And I don't know. I went into this that. It's not bad, but it's like. What am I, my knowledge? Make a shot.
All rise. Hear ye, hear ye, hear ye. The Court of Appeals of the State of Kansas is now in session. The Honorable Sarah C. Warner presiding.
Good afternoon, everyone. Please be seated. I want to welcome you all to the afternoon session of the July oral arguments before the Kansas Court of Appeals. My name is Sarah Warner, and I'll be presiding over today's docket. With me, I have a distinguished panel of judges. So to my right, your left, is Judge David Bruns. And Judge Bruns joined the Kansas Court of Appeals in 2011. He came to the bench from Shawnee County District Court and then from private practice before that. And then to my left, your right, is Judge Lori Bolton Fleming. And Judge Bolton Fleming is the newest member of our court. She joined us in April, but she came after a distinguished career as chief judge in the 11th Judicial District down in Pittsburgh. So we're happy to have Judge Bolton Fleming joining us. We have two cases on this afternoon's docket. As I said, I'll be presiding. That basically just means I'm going to be keeping time, trying to figure out how to use this. And so I ask for a little bit of grace as this may be the first digital timer that was ever created. And so we're all lucky that we get to experience this together. But in preparation for today, we have thoroughly reviewed the briefs, the parties' arguments, the record on appeal, as well as a research memorandum prepared by a research attorney here at the court. So we are very familiar with the facts in each case, but we are live streaming these arguments. And these arguments are being archived on our Court of Appeals YouTube page. And so for that reason, I'm going to ask the appellant's attorney to just, in each case, to just give us a minute of a summary of the facts of the case so that we have a little bit of context about what's going on. And I'll give you a minute or two so it doesn't count against your time to do that. But with that, I'm going to call the first case on this afternoon's docket. That case is from Shawnee County, case number 127791, Sane F. Kina, appellant versus State of Kansas, Department of Children and Families Vocational Rehabilitation Services appellee. Would the parties please come forward and then state their appearances?
Leon Flores Jr. for the appellant, Sane Kina.
Thank you.
And good afternoon, Your Honors. Mark Altenberg for DCI.
Thank you. Mr. Flores, would you like any time for rebuttal?
I would like to reserve 3 minutes if I may.
3 minutes are granted. Give me just a second as I figure this out and then. Sir, you may begin when you're ready.
Good afternoon. Thank you. This case comes on before this court from a district court action, which originally began in the federal court system as a Title VII claim, along with a supplemental claim under the Kansas Act Against Discrimination. For jurisdictional issues and reasons, the case was dismissed from federal court in November 11th of 2022 and was refiled under the statute in Kansas, case 860-518, within 6 months from the dismissal. It was actually filed approximately 5 months from the dismissal. The plaintiff in the case claimed discrimination in terms of national origin and gender-based discrimination by the Department of Children and Families in her employment there. And it was, as I indicated, refiled after having been timely commenced in federal court on April 10th of 2023. Primary reason why we were here is that the summons was issued, but it was not served until what is essentially 92 days after it was filed. And as we are aware, generally, commencement of the action relates back to the date of filing when you obtain adequate service or sufficient service within the 90 days, which would have expired on the day before the service was actually accomplished. In this case, the service was made, and about a month later, there was a motion filed to dismiss the case based on a statute of limitations argument. It is our contention that the untimely service amounts to insufficient service of process under 6212B, I believe it's 4, and therefore is subject to waiver. And the general entry of appearance that was filed the same day that the case was served, July 11th, waived that insufficient service of process, and that defense that was pled later was weighed by the defendant in this case, and that the case should have been allowed to proceed forward.
Is there a difference? The appellee's brief draws a distinction between sufficiency of service and the timeliness of the service. Could you respond to that?
In my review of the case law, there's no real clear decision in Kansas on what actually constitutes, in my view, in my research anyway, insufficient service as it relates to timely service. But as a general rule, it does appear that particularly some of the federal cases, and that it's alluded to in some state court opinions, that if it is untimely, it is insufficient. And so I don't know that that directly answers your question, but it's a difficult question to I think address, because it is subject to waiver either way, as a statute of limitations under 12B6 or as a sufficiency of service issue, which we claim in this case the defendant waived by filing a general entry of appearance without any reservation of the claims on the day it was served. And so either way, we believe that there was a waiver of the defense, the affirmative defense of statute of limitations, or the sufficiency of service of process.
Counsel, this doesn't really, this doesn't go to the statutory question, but I've just been thinking about the way practically the rule that you are suggesting would play out, and in a state that has electronic filing, as we do, that basically the entry of appearance allows someone to get all of the notices and is necessary to kind of step into the electronic filing system. Have you thought about that at all? And
well, yes, I have a little bit, because we could file a documented case without having to file an entry of appearance. You can file a motion to dismiss after service is made, or file an entry of appearance to get notices, but there would be no notices issued until service is accomplished. So there'd be no reason for any particular rule to distinguish the general filing of an entry of appearance from a motion to dismiss. And so I don't think it has any bearing on the facts in this case as they're presented. Another issue that I wanted to raise is that there is this claim of the statute of limitations. This case was refiled 5 months after it was dismissed, and could have been refiled as late as May 11th of 2023, which would have extended the 90-day service period to August 9th of 2023, and the service was had clearly before that date. And as the defendant has maintained in this action, it was properly served there was no, the person who received it was authorized to receive summons. It wasn't that they that it was insufficient in that regard. And so it's our contention that the waiver applies, but if it doesn't apply, then the case clearly was brought within the statute of limitations, as we could have filed it a month later and the service would have been extended to August.
Have you come across any case that does the counting like you just suggested that we do, that like instead of looking at the date it was actually filed and under the statute counting 90 days from that date, looking at kind of the last possible date it could have been filed and counting like a grace period? I haven't, so I was wondering if you found any.
No, I haven't. I found some close that were, there was a medical malpractice case filed where it was timely commenced and then there was an issue of waiver, but, and I don't have the site off the top of my head right now. I was reading that this morning and it was like, well, this really doesn't apply because it's a whole different case, except that the initial action was timely commenced. There was no assertion of a statute of limitations defense there, even though it could have been asserted. And the court deemed it to have been waived by the subsequent filing and the failure to assert it at that time. Now, I don't know whether you have any questions about the issue with regard to whether or not the filing of the entry of appearance, general entry of appearance constitutes a waiver. But I did come across one case in Kansas. It's an unpublished opinion from 2023 that distinguishes between a general entry of appearance and an entry of appearance that reserves the challenge to personal jurisdiction and was found to have been a waiver of the defenses under 6212.
Is that case cited in your brief, counsel?
It is not. It's an unpublished opinion. I do have it here. It's the Credit Union of America versus Lunkwitz, Lunkwitz. It is, as I indicated, an unpublished opinion, 23 Can-App, Lexus 75, 524 P3D 459 with the Westlaw site of 2023 WL 2195774. And in that panel determined that although it was denominated as a simple entry of appearance, in the body of the entry of appearance, counsel clearly indicated that they were filing the entry of appearance for the purpose of challenging the jurisdiction of the court, and that was sufficient to preserve the defense. Absent that, the general entry of appearance constitutes a waiver.
Was that a personal jurisdiction case, counsel?
It is a, yes, it was. It was for the purpose of challenging personal jurisdiction.
And I don't know if you have a position. I kind of presume that you do, but does that same analysis apply when we're talking about a statute of limitations? Meaning the same waiver analysis that would apply in a personal jurisdiction analysis?
I believe that it does because, again, although a statute of limitations can be raised at different times, you have to preserve it under 6208. The failure to assert it initially constitutes a waiver, in my view. Now, in the state's brief, they argue that the service was proper, but that the filing being late constitutes a untimely filing that must be dismissed. The admission of the sufficiency of the service, I think, though, eliminates that argument because they have admitted that they were properly served, and then they waived the defense when they essentially didn't take the time to look at what had happened to make a determination as to whether or not they were subject to the court's jurisdiction and just entered without considering what their first move should have been.
What is your, is your view then that what what the department should have done here. Not that you want to counsel the department and these kinds of, but that what the department should have done is to wait to enter an appearance and just file a motion to dismiss and have that be the first thing that was in the case.
Yes, because it has to be asserted in the initial response, or initial pleading that's filed under 6212. Filing a general entry of appearance waives all of those other defenses.
So just to make sure I understand, so your position would be any affirmative defense would be waived if not stated in the general entry of appearance?
Any of the 2 through 5B defenses, yes,
Okay.
without a reservation.
And here, there were no mention of defenses at all, just
In the answer, in the,
in the entry of appearance.
correct.
And then the case you cited, it sounded like they did try to throw in some type of defense in the entry. Is that correct?
Yes, they did. And the district court dismissed it because of it was denominated as an entry of appearance, even though it was limited. And then on appeal, the Court of Appeals panel that heard the case reversed and said, no, this is a clear reservation of the affirmative defense. The district court should
That's
be
what they were
reversed.
attempting to do. They
Yes.
didn't want to come in and enter an appearance and then say, hey, you've submitted to a jurisdiction.
Yes.
Other questions from the panel? All right,
Thank you.
you've reserved 3 minutes for rebuttals. So
Thank you.
you back up here.
That just run out.
Council, give me just a minute to, I would say to figure out the technology, but I'm not sure if we could, denote that in this.
Here you go.
All right, we're ready for you.
Good afternoon, Your Honors. Again, and may it please the court. Again, my name is Mark Alton Burns, and I represent the Kansas Department of Children and Families. It sounds like to me the parties agree on all the material facts, which is the filing dates of everything. So we don't need to go through that again. The appellant conflates personal jurisdiction with the statute of limitations. They're not the same things. We don't contest the court's personal jurisdiction. We don't contest the sufficiency of service. If we did, we would have filed something under 212B5. We didn't. We're contesting the timeliness of the filing, and that's under B6. Although I have read some cases that put it under B1, but the point is those B2 through B5 that counsel's referring to that he alleges or that he argues are waived by the filing of an appearance without anything else, it's irrelevant to this case. We filed under B6. The argument that untimely service equals insufficient service is taken from, and I'm going to say generously taken from this unpublished federal court case that counsel cites in his brief, Martinez-Jones versus Dolce Independent Schools, which is 2008 WL 2229457. That case does not say that insufficient service is the same as untimely service. In fact, what it says is the defendant in that case preserved his objection to timely service because he put it as an affirmative defense in his response to the complaint. There's no requirement, well, strike that. In terms of the statute of limitations argument, there's no requirement that statute of limitations be mentioned with an appearance. There's no case law that says that. The statutes don't say that. In fact, all the statutes in the case law say is if you want to preserve a statute of limitations defense, you either need to do so by filing a motion to dismiss before the initial pleading, which is what we did, or label it an affirmative defense in the initial pleading. And an appearance is not a pleading. It's not a response. It's not a motion. So it is simply without merit to argue that a statute of limitations affirmative defense needs to be mentioned in an appearance to preserve that defense.
Counsel, it looks like the district court was looking at this under B1 perhaps, and was talking about it in terms of jurisdiction. Do you think this is a jurisdictional issue? Like, where did that discussion come from?
Well, my recollection of it is that the court brought up the subject matter jurisdiction on its own. Again, we filed under B6. As I previously indicated, I've seen motions to dismiss on the basis of statute of limitations filed under B1 for lack of subject matter jurisdiction. I've seen courts kind of consider them to be the same. The significance of either B1 or B6 is that they are not as easily waived as B2, 3, 4, and 5. So as we brought in our brief, even if the district court made the ruling for the wrong reason, let's say this court finds that it's not a subject matter jurisdiction issue, it is a B6 failure to state a claim issue, it still should stand because the filing was untimely.
And the ultimate action dismissal is the same.
Correct. That is correct, Your Honor. So again, just to reiterate, the filing of an appearance does not waive the statute of limitations argument. And because we agree on all the dates, counsel's already indicated it was filed 92 days after, it needed to be filed 90 days after. Now, this leads into counsel's second argument, which is a new argument. This is not mentioned in his written brief, which is to say, because, and I'll try to encapsulate it, because they refiled their complaint in state court within 5 months instead of the 6 months. I think counsel is asserting that extra month should be tacked on to those 90 days. I think that's the argument.
Or that the 90 days should run from like the end of
The end of the 6 months, correct.
Right, yeah.
There's nothing that supports that contention. In fact, the statute on point here, which is KSA 60-203, doesn't make any caveat to that. It simply says that you need to get service, you need to effectuate service within 90 days of filing to be able to relate back to that filing date. If you don't do that, the filing date, the case commences, in quotes, when you get it served. So that argument is a new argument. I haven't had a chance to look at it in great detail, but just looking quickly at KSA 60-203, it doesn't seem like it holds water because of the clear and unambiguous language of that statute. Again, this other case that counsel cited, this unpublished case, Credit Union versus, I think it was Lundquist. I don't know what that says. It wasn't in the brief. It's unpublished, so it's not authoritative over anything. So I would ask this court to disregard that case.
Well, hopefully over some things. Right?
Well, hopefully over something, yes.
Yeah, right.
Yes. I'm sorry, I didn't mean to be so flippant, but yes, it is.
Over the parties.
Over the parties, yes.
Right, yeah.
Yes.
And if any of us are on that panel, then who knows?
Maybe it's very
Yes.
same. Yeah,
Yes.
but no, not to be taking any of this lightly. We of course don't. Right.
Thank you, Judge. So I've got 8 minutes left. I don't need to belabor the point here. The timeline is established. It's undisputed. Case was filed late. It's as simple as that. The district court made the correct decision, even if it made it for maybe the wrong reason. It made the correct decision in dismissing the case, and we ask that this court affirm that finding.
Any other questions from the panel? All right. Thank you very much, counsel.
Thank you.
Counsel, you have 3 minutes of rebuttal. Give me just a second. I'm starting to get good now. So.
All right, start to brag.
That's right. And very humble. So you may begin.
When the district court found that or asserted, as counsel for DCF stated on its own, basically whether or not it had subject matter jurisdiction, clearly it did have subject matter jurisdiction, had jurisdiction over this kind of a claim. And in Kansas, we're noticeably state, and it's pretty hard to not have jurisdiction over a claim so long as it's even vaguely stated, unlike in the federal system. And so the court was, I believe, incorrect legally in that regard. And I think we probably don't disagree about that between the parties. But then the question is again, should that, was there a waiver? And it is our position that there was a waiver, that the case was timely asserted, and that the failure to consider the defenses that may have been available prior to entering the appearance in this case require that the court find that there was a waiver and that the actions of the district court should be reversed. And rather than belabor it, unless you have any other questions based upon what was asserted, I will
Any question?
submit to the court.
All right, thank you.
Thank you.
Thank you. Thank counsel for your arguments in this case, for your briefing. We take the matter under advisement and we'll issue a written opinion as soon as we're able. Thank you very much.
Thank you.
With that, we'll let this run and we'll come to the second case and the final case on today's argued docket. That case is from Riley County, case number 126068, State of Kansas Appalachia versus John Francis Holwell Appellant. Would the parties please state their appearances?
Good afternoon, Your Honors. Corinne Gunning, the above your office appearing on behalf of Judge Walpole and Chief Judge. I request 3 minutes for rebuttal.
3 minutes are granted and welcome back.
May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas.
Thank you. Ms. Gunning, give me a second and we'll go ahead and get started. All right. You may begin.
Okay, this case comes to this court following a jury trial in which John Caldwell was convicted of offenses stemming from a violation of protective order alleged by the state. He and his girlfriend had a very tumultuous relationship. There's no dispute about the record about that. It was a roller coaster relationship on both sides with ups and downs, as John described, between being very lovey and very hateful, which led to a breakup. Though the parties disagree about when the breakup happened, the contact between them shows that it continued through her seeking an order of protection, a temporary order of protection, in May of 2021, with a final hearing set through that order in June of 2021. After that temporary order of protection was issued, John continued contacting her, and so she called the police. And the officer who responded to that call testified that when he responded, he saw the order, but that a different officer had signed that order as having served it on John personally. However, once we went to trial on this case, and actually throughout this case, the state never presented the testimony of that officer who signed it as having been personally served. And the officer who had simply seen the order and began the work to arrest and eventually charge John was the inappropriate person to bring in that document and provide the foundation for that document to be admitted. So the state never proved that John was personally served with the temporary order of protection. And that is a critical element of stalking in violation of a protective order. So the two issues that I've raised in this case are somewhat intertwined and necessary to be evaluated together. The first is that there was not foundation for Exhibit 2 in this case. And the second is that because of the document showing John was served was not supported by adequate foundation, there was also insufficient evidence to support a conviction for violation of that order.
I'm going to stop you for a second.
Yes.
So I spent quite a bit of time with the transcript on this one.
Mhm.
So as I see this play out, so Exhibit 2 gets offered and defense counsel objects on foundation, which we know, has no statutory basis. It's basically the document or the exhibit is what it purports to be. That's fine. So then in response, the judge says, well, I think there could be a hearsay problem. I need to go get my big book.
Mhm.
Then the prosecutor responds, well, it's okay because I'm going to authenticate it under the statute. I'm going to get it. So what I could see going on in the transcript are maybe actually three issues: foundation, and then kind of tied in, but yet separate, authentication and hearsay. Do you believe an analysis under all three of those areas is appropriate, or do you want it narrowed to simply what you raise?
In my preparation of this and reading the record, of course, myself, is that the only objection raised by defense counsel was to foundation for the document. The court's analysis and ultimate determination on it was based on hearsay. I'll be honest, the way that I raised it is based on the objection because that is how case law seems to indicate I am supposed to do that. However, I think that there is an intertwined hearsay question because is the foundation provided for this sufficient to overcome this hearsay problem? And my response to that would be no, that while we have two documents in this case, we have Exhibit 1, which is the temporary order of protection, and there's no dispute that that order of protection exists. So for its existence, I don't think that there's a problem. What they wanted was then to bring in Exhibit 2, which shows that John was personally served, which is an element of the offense. They want to bring that in to show that element. And the hearsay exception that is applied throughout the case is simply insufficient to solve that problem. It's offered for the truth of the matter that John was personally served with this document, that he was aware of it, that he knew it existed. And so I don't think that the authenticated document exception necessarily is sufficient to overcome the hearsay problem there. And which brings us back to we're lacking the foundational witness to show why they should allow this in without that witness's testimony. There's no indication of the fact, there's no evidence that John actually was personally served except for that signature. And the officer who brought this in, the authentication, cannot say, cannot suffice to show that he was personally served. I don't think it overcomes that problem.
So the first document, which is the protection order itself, you say that came in, that was fine. I guess I'm having a difficult time distinguishing between those two documents because both were court filings.
Mhm.
So why is it that it's okay for Exhibit 1 to come in, but not for Exhibit?
Because I hopefully I can explain. I mean, from how I was thinking through this is, if we have this document that says this temporary order of protection was filed, I think that is sufficient to say, yes, this is a document that exists, and Officer Krause was perfectly fine to rely on that document in order to arrest John, to have probable cause to arrest him for violating that order. But then once we get to charging John with violating the protection order, and then the burden of proof that the state has at trial, one of the required elements of what they charged him with is that this order was issued pursuant to this particular statute, and that he is either was personally served with it or has notice of it. And so one is to show this exists, this is a thing that exists, and then you have another additional element which Officer, I can't remember his name, Gambrel's testimony would be necessary to show, yes, we satisfied that element of this offense. He was personally served with this. So the documents are different, and John is not denying that they exist, that this order of protection was filed, that it was in the court record. Just that what we're arguing is that there's no evidence that he actually was personally served with it. We don't have the witness to testify about it. And I don't think that just the hearsay exception of a court filed document overcomes that problem.
So if I understand, Exhibit 1, you're saying basically it wasn't hearsay because it was offered for a matter other than the truth. It was offered to show why the officer did what he did.
Yes.
And Exhibit 2 was offered to prove an element of the crime.
Correct.
And now, and I've not went back and read the transcript. I'm looking at the actual exhibit 2. It is at least the one I'm looking at is a certified copy by the clerk of the District Court of Riley County, Kansas. So I'm wondering, even if it is hearsay, why the exception under 60-460, what is it? 0 and, or I don't know if it's 0 or O, probably O, and 6465 for authenticating it as a official record without additional extrinsic evidence, why that wouldn't apply.
And I think my response sort of remains the same, is that I don't think that that suffices, that exception suffices to overcome that. Again, like, to prove that Officer Gambrell did what he actually said he did. So
But if it's admissible, whether it's foundation authentication, then
Yeah,
then it's in the record. And then it's up to at that point, the document speaks for itself. It seems like.
yeah, I mean, my response would be that the signature of a person signing a document to indicate they personally serve someone shouldn't
Certainly
fall under
best
that.
practices would have been, why not bring this officer in and
Right.
said, hey, I did this.
Unclear why that necessarily didn't happen in this case. But I don't think that it should be self-authenticating because of the contents of it. Would be my response, is that because the contents of it is more than just, this is a document that is being filed with the court. I mean, lots of documents get filed with the court and we still bring in the cop that filed the report or filed, the documents that happened in the case.
I'm having a little, and I think that you did explain it, but I would like you to explain it again, why this is a foundation issue and not just a plain hearsay issue. I understand you're dealt the record that you have.
Yeah.
I
I
understand.
mean, it's foundation for the document, because the person who can testify that John was served with this document is the officer who laid eyes on him and handed him that document. And this is one of the rare civil statutes that requires personal service. And so I believe that that's what is in defense counsel's mind as he sees that officer is not present, and that's the objection that is made. And then it turns from there.
Pivots
to
into
say-
hearsay.
To say we don't need a foundational witness because it's hearsay. And so there's no actual hearsay objection because it got there. And the state maintains that response throughout its briefing. The reason I raise it as foundation is because that is the objection that was made.
Is there anything about KSA 6460? So the language itself that gives you heartburn about the admissibility of the document as a hearsay exception versus just kind of like your overall feeling that this is wonky. It doesn't feel like this should be right. I mean, I'm looking at like the statutory language. I mean, it's certainly a writing purporting to be a copy of an official record. It seems to me it is, but maybe you disagree. Is there a reason it is not a copy of an official record?
I would say I don't have any particular
Okay.
reason to say that it is not. My response just remains, I don't think that these hearsay exceptions overcome the problem that we have, which is that an element of the offense requires this, and I don't think that we can have these self-authenticating documents simply serve to
prove
prove that particular element. And I know that it happens in other cases where an element is proven by hearsay documents, or may be proven by hearsay documents. But I think that when we're dealing with this, and I'll be honest, we have a lot of these cases coming up where somebody there's no evidence or there's scant evidence that someone was actually served with a personal document, personally served with these documents. And that's the only way these people who have temporary orders of protection against them know that that happens, know that that is happening, that they can then appear at the final hearing, is that they have received this document. That's the only way that we protect their rights, is that they get personal service. And if we simply then can have these hearsay documents because it ultimately gets filed, and say, okay, well, that's good. I think that we're running into a violation of someone's rights there if we're just saying that hearsay documents can prove something that you may never, ever actually have received notice of, because a cop signed it and then it got filed in court. So I know that's sort of a extended answer to your question, but yes, it is more of a gut feeling and less of I have no dispute that it is a document that was filed in court, and they presented a certified document, a certified copy of it.
Thank you. Any other questions from the panel? No. All right, thank you very much. You have 3 minutes of rebuttal, and Mr. Loudon.
Good afternoon again. I'm Dave Loudon, Deputy County Attorney, appearing on behalf of the state. With regard to the first issue, I think this comes down to, the simple objection was foundation at trial. And the question is, did the judge abuse her discretion by allowing that to come in? The judge talked about this was a self-authenticating document. Okay, it's clear the judge was right on point with what it is. Foundation is a way to gauge reliability of a piece of evidence or to authenticate whatever that is. That's what foundation deals with. KSA 6045 or 60-245 indicates that this document was a self-authenticating document. So I don't believe that the appellant can show that there was an abuse of discretion in this case. They're not even challenging that the document came in. It's what was included in that document. I hear a lot of talk today about hearsay and whatnot, and perhaps that was the better objection. We can't tell whether Officer Gambrill served this document that this other document says that he served. If you want to test the reliability of that, it's through a hearsay objection or confrontation objection or something of that nature. That wasn't made in this case. As Ms. Gunning has already pointed out, she's somewhat hamstrung. This court acknowledges she's somewhat hamstrung by what was in the record, because we all know that under 6404 in State v. King, there must be a contemporaneous objection to an evidentiary objection to preserve that for appeal. So the only thing we're dealing with today is foundation. The court found that this document was self-authenticating, as it could under 60-245. For that reason, the state would submit that there is no basis to find the judge abuses discretion and should affirm the convictions on, at least on that. As Ms. Gunning also noted, her second issue kind of bleeds into that whole thing. The only thing I would note about that is, even if this court rules against the state in the first issue, it cannot excise that information and find there was a lack of sufficient evidence in the case to prove the 2 counts in issue. Any kind of relief that would be sought would be a remand for a new trial, not a finding that there was insufficient evidence.
So you several times you referred to self-authenticating, but here the document was authenticated by the clerk of the district court, was it not?
It was, and I said 2, I'm misstating. 6465.
Yeah, I actually have some statute books down there, which is kind of nice. So I looked it up, 60.
Yeah.
So whether it's a hearsay objection under 460, subsection O, simply content of official record refers you over to 6465. So it seems like it was, even if it was a hearsay objection, if 465
Right.
applies, then it would be admissible, notwithstanding it being hearsay. And it looks like under 6465(1) that No, nothing else is required for admission to the evidence if the office in which the record is kept is within the state and the writing is attested as a correct copy of the record or entry by a person purporting to be an officer, deputy, an officer having the legal custody of the record. And at least on its face, it looks as if that was done. And so it would be, I mean, authentication is actually a better term than foundation. Foundation could be all kinds of things, but isn't authentication really the official way to get a document into evidence?
It is in part, but I think my point to that was the reason that we require foundation is to make sure that the evidence is reliable and somebody has some, can testify about whatever that is and that document can come in.
Which would be better, and it would have been better if you would have called the officer in, but
Right.
once it's into evidence, it seems like it speaks for itself and the jury can give it whatever weight. The attorneys can argue as to the weight. Did you try this case? I don't know.
I did not.
Okay, do you know whether the attorneys argued about whether or not he was actually, the Officer Gamble actually served him?
I don't know other than what's in the record regarding.
Because I would think they could still argue that even though it's in the record. It's just up for the jury to decide what weight to give that document.
Correct. I mean, at that point in time, the defense certainly could have put up a defense that relied upon calling Officer Gambrell. I think at the time, Officer Gambrell had retired maybe and gone on something else, but he's in Manhattan. So I don't know why they didn't do that. But again.
Or the defendant could have testified, no, I wasn't actually.
And
the person.
nobody served me.
Nobody served.
Right.
Right.
And, I can appreciate, the box that Miss Gunning is in just because of the, he didn't say hearsay or anything of that nature.
But I think the result would be the same since hearsay subsection O would be the exception, which refers you over to 6465.
Which may leave her with a, constitutional confrontation issue or something of that nature, but I think there's.
Yeah, but it does feel a little bit like proving an element of the offense.
Right.
By way of just a document and no testimony, no discussion. I mean, I suppose that it is a little comfortable.
Well, it may be, and I don't know that it's any different, just when you look at it, in a general sense is like, okay, well, I wasn't there to take a picture. Here's a photo of a crime scene. I've been to this spot a million times, so that accurately represents whatever it is. I mean, there's always going to be something. We obviously put in evidence of all types to help us convict and prove elements. That's why we put evidence in. So to focus on that part, I think would be a little bit.
Of course, in that example that you just gave,
Yeah.
you have the person who took the photograph who can be cross-examined.
Well, that's what I'm saying. It may not be the person who took the photograph. Somebody can take the stand and says, I live there. That's exactly what this.
If
looked
they'll
like.
say it's a true and accurate representation.
Right, as long as they, right. And, again, even going to the confrontation, I think there are cases out there that indicate this still wouldn't be a confrontation issue. Because this wasn't done in the course of, litigation or anything. It was just, hey, I served this thing in a civil case. And here we are in a criminal case, so. But anyway, if this court has no other questions, I would submit the issues on the brief and ask that this court affirm the district court and affirm the convictions.
Thank you. Any other questions from the panel? All right, thank you very much.
Thank you.
Ms. Gunning, you have 3 minutes that you've reserved for rebuttal.
I guess I would first, start with, that I think we kind of gone around here of like that whether or not we've got hearsay or not, is it admissible in this case? And we don't have the person saying, I served this there. And I don't think that the hearsay exceptions should apply to allow us to bypass the admissibility question there. So while it may be that the content, the existence of the document may come in under the hearsay exceptions, to use that to then say, and it is sufficient to show that this person actually did this thing.
But wouldn't it be circumstantial evidence at the least? And I think we've said the most serious elements can be
Sure.
shown by circumstance.
Sure, there's a couple of things that give me pause about this is that one, Chief Judge Warner, you said that, well, certainly Mr. Caldwell could have testified. He has a constitutional right not to. He has a constitutional right to have the state prove every single element. And he has a due process right to be served with this before he then is charged with a crime for violating this. And so I think that while we have a case law that says, sure, this might be circumstantial evidence, I think we do have to look at what are we using some of this evidence to prove, and should it even come in for that purpose? To bring in the document that says, yeah, this thing existed, Exhibit 1, without that signature, it's a totally different question than to bring in the Exhibit 2 with the signature to prove this particular element, that he was given notice of this document before he was arrested for violating or convicted for violating. And so in these particular cases, I think it's a lot bigger deal than just, oh, I have this civil case out here and I'm going to serve this document. We have actual rights at issue that then bleed into criminal prosecution. And as I said, I don't think that we can then ignore this, that we still have sufficient evidence on top of that, because I don't think that without this particular document showing that he was personally served and proving that he's personally served, that we have a sufficient evidence that he was on notice or that he was actually personally served with this. And so it is the admissibility of the document. And I know that there might be some questions about, is it really weight versus admissibility? What are we doing with that? I think I would still stand on that is this document without Officer Gamble's testimony should have been inadmissible or for proof that he was actually personally served with this document. And for those reasons, I think that the court erred when it admitted the document, and the conviction can't be sustained for that reason. And without it, there's insufficient evidence to show that he was personally served or had actual notice of the document.
Thank you very much. Further questions? Thank you for your time. I want to thank both counsel for their excellent arguments in the briefs and today. And we take the matter under advisement. We'll issue a written opinion as soon as we're able. And that concludes today's docket. So court is adjourned. Thank you.
All rise.
Hey, been a long time.